Podcast Litigate. Collaborate, innovate, advocate for disability rights. Welcome to Litigate. In this podcast, we talk about the real challenges faced by persons with intellectual and psychosocial disabilities. Many people with intellectual and psychosocial disabilities face discrimination and barriers to justice across the EU. But legal action can drive real change. That's where strategic litigation comes in. It's not just about winning cases for individuals, but challenging unfair laws to create lasting impact. Through strategic litigation, advocates are working to hold the system accountable. In this podcast, we will explore these legal battles, meet the experts behind them, and uncover how the law can be a tool for justice. Brought to you by Litigate, funded by the Citizens, Equality, Rights and Values Programme of the European Commission.
Good morning, good afternoon, good evening, or whatever time of the day it is where you are. I am your host, Rita Crespo Fernandez. I am the Human Rights Coordinator at the European Network on Independent Living. The European Network on Independent Living, which is also known as ENIL, is a user-led network and a forum for all disabled people and their allies on the issue of independent living. Today, we will be discussing a case on the topic of European Union funds and their misuse to finance institutions. This particular case took place against Bulgaria and was carried out by the European Network on Independent Living, the Validity Foundation, and the Center for Independent Living in Sofia, against the European Commission. It was taken over by the European Court, the General Court in this case, at the European Court of Justice. And if you would like to look it up, the reference is case T613/19, and it was decided on the 2nd of September in 2020. The misuse of EU funds is one of the main topics we work on at ENIL, because we have observed throughout the years multiple investments into institutions, small group homes, shelter workshops, special school, etc. We have tried many avenues to tackle this issue. We have tried complaining to the European Commission, we have tried discussing, stop the investments at the country level. Nothing has worked so far. We have always run into walls. So one of the avenues we took at one point was strategic litigation. In this particular case, we wanted to challenge the use of the European Regional Development Fund in Bulgaria that was aimed to support the institutionalization in the country. Instead, we observed that the money was going to be used to invest in institutions, in particular in small group homes, in the transition from bigger institutions into smaller institutions, which, according to the Committee on the Rights of Persons with Disabilities, is not an appropriate form of the institutionalization. At the time, Validity and ENIL and the Center for Independent Living in Sofia tried different avenues to stop these investments from happening. They requested the managing authorities, which are the ones in charge of managing the funds at the country level, to suspend the funds. This was rejected. Then this was addressed to the European Commission. As the European Commission is in charge of monitoring the use of funds, again, rejected. So the organizations took the case to the General Court. However, as we will learn from our speakers today, the court declared this case inadmissible. And our speakers today will tell us why. And why is still this decision important? How can we address it again in the future? What other avenues we may need to? And also, why strategic litigation? And why would you like to do strategic litigation maybe in your context? So today we will have two guests speaking to us about this topic. We will first hear from Bart van Vooren, which works for Covington Burling in Brussels as a partner, and from Stephen Allen, who is the Executive Director at the Validity Foundation, which again was one of the partners in this case, and Bart was one of the lawyers involved in representing the two different organizations. I'm sitting here in Brussels today with Bart van Vooren, partner at Covington Burling, a law firm here in Brussels. Bart, can you tell us a bit more about the work of Covington Burling first?
Covington is a US headquartered law firm, but we are here in the Brussels office. In Brussels, we focus on 4 areas of law: antitrust, competition, life sciences, technology, and then policy and law, EU policy and law. And I am in the life sciences team, so EU regulatory lawyer background.
And how did you come then to get involved into the case we're discussing today?
There's a bit of a story, I guess, also in terms of my personal background. I regularly joke that I wanted to be a human rights lawyer, I specialize in human rights law, also in my LLM during my degree. I did a PhD in EU and international law. I was even a law professor for a while, but I did not like teaching. And all my students were usually on social media while I was speaking to them in class. So that was frustrating. And then so I decided I thought that through teaching and academia, one could have a lot of impact. And it was a bit too much ivory tower for me. So I went into private practice. But this background, this interest in international law and human rights law never really went away. And so then at Covington, we do have a very strong pro bono practice. So there is a strong incentive for every lawyer that is here across any office in the world to try to at least give 50 hours of pro bono time away, if not more. So for instance, the case that we talked about took a whole lot more time. And so it's for me, a personal interest, background interest, and also our associates and other lawyers who want to do it, get to have fun with pro bono and strategic litigation, topic of the day.
So regarding strategic litigation, here in this case, we were trying to redress the misuse of EU funds. Why did we choose the path of strategic litigation in this particular case?
I remember, so I first joined ENIL's office in 2018. And so with your colleagues, Ines and others, public policy team, and I was at the time not really familiar with the UN CRPD, the right to independent living. And so that it was you and then also the colleagues at Validity who explained to us, like, here's the problem. You have EU funds and they go to, in essence, segregated communities at national level. How can we challenge this? And so what we initially did is we said, okay, so we are an EU regulatory team. Like I said, we do pharma and food law and biodiversity law and everything, but we know EU law quite well and EU court procedures. So we, together with your team, looked at, okay, how does this money actually go from the EU to national level? And then we actively sought out means through which to challenge this. Now, it's a very frustrating EU mechanism called shared management, whereby basically the EU and the member states each have part of the responsibility of managing the money. But as you can imagine, when two people are responsible or two levels are responsible, no one is ever responsible. So EU says it's national, national says it's EU. So that's something that we had to navigate. And so what we did is we with you said, okay, what if we invite the Commission explicitly to take a position on, in that specific call for funding, to suspend the money? And we provided the legal arguments to say, well, you, the Commission, have the power not to give the money to the member state, in this case Bulgaria, but it could be Hungary or whomever, and you have that legal power. Now we already, between us, we discussed, is it going to be easy to challenge this? Procedurally, no, but it will be a starting point. So the essence of strategic litigation was we actually triggered the case thinking in advance by basically compelling a government authority, in this case the Commission, to take a certain position that we could then attack later in court. And so that's what we did. We invited the Commission. They took a position. They said, no, we cannot suspend. It's up to the member state to how they spend the money. And then they also made comments on as long as the initial program is in line with human rights, it's not up to us to look at individual calls. So there were some technical details involved. And they said, no, we can't act. And that was then the let's say the legal decision that we went to court against. So we created the case in essence.
To our listeners that maybe are not very familiar with the European Court of Justice, can anyone go deposit a claim, in the sense that do you need to have some certification? How does it work? Is it like any other court? How do you go about this?
Okay, so that's a very good question. So the Court of Justice has two levels. The first is the general court, where you can file what is called direct actions, where Essentially, you, me, person with disabilities, anyone who is individually and directly concerned by a legal act can file an action. There is actually somewhere also Bart van Vooren versus European Commission. That's another funny story. Anyway, and then there is also the Court of Justice, whereby if you are before a national court and an issue of EU law comes up, then you as a litigant can ask that national court to ask questions to the EU Court of Justice. So those are the two biggest avenues. And for this case, we were in the first scenario, we filed a direct action for the European Network for Independent Living and Validity against that Commission decision.
Did you also try to refer a question? I believe this is a very common strategic litigation strategy, let's say.
Yes, and I think we've worked on other areas, for instance, in voting rights for persons with disabilities. But unfortunately, I am a slightly odd Belgian qualified lawyer. I've done a lot of EU court litigation, but I haven't really seen the inside of a national court. So the way that works is we would then work with national lawyers, and I have a colleague who is Bulgarian qualified, for instance, so she can help in Bulgarian courts. And then what we do is, for instance, we've done a big case on gay rights in Poland, where we worked with a Polish law firm, and we handled the case before the Court of Justice and won. Yay.
Congratulations. So you're a bit of a special lawyer, let's say. You need to be certified to be able to go to the European Court.
Any EU qualified lawyer can do it, but it does help to have an area of specialization, because it's a court that many lawyers across Europe don't usually see, and so that's why we often help and we stand there alongside national lawyers. Also, we don't speak all languages of the European Union, so a case that comes out of Bulgaria will typically be in Bulgarian. So then we help with the legal arguments, and as simple as, here's the court, and that's where you enter, and that's where you stand, and all these kind of basic things. But then on the substance, our colleagues at national will help.
So if we go back to the arguments, you mentioned first the notion of share management, which is already a big monster to tackle. There is, I guess, a second monster, which is what is the place of the Convention on the Rights of Persons with Disabilities in the European Union? Because as many of our listeners may know, the European Union has ratified the Convention, but the European Union is not a regular state.
No.
And the decision in which the European Union looked at how do we apply the Convention was not so clear-cut. So how did you take this question when you were preparing for this case?
Yeah. So we went... the fun thing being a lawyer in strategic litigation for non-governmental organizations such as yourself is that you can take very principled stances. So we said, look, there is the right to independent living in the Convention, and there is access to justice in the Convention. You have those two articles, and you, the court, must enforce this, and the European Commission must comply with it. You're a party to it. Now, and I don't know if this is the place here, but then the enforceability of international law before EU courts or even national courts is a big issue of debate. Can you actually invoke an international treaty or not? We said yes. Now, and to my big frustration, for the record, we didn't win the case well, we can talk about defining winning, but then you'll think, this lawyer. So actually, we went even on appeal, and we, for instance, because I mentioned earlier, if you file a direct action, you need to be directly and individually concerned, right? You need to prove that somehow the decision of the EU affects you. And in essence, the General Court had said in its first judgment, look, you are not affected by this. You are an NGO representing the rights of persons with disabilities, but this doesn't affect you. We made the argument, look, one, in this Bulgarian case, we know that there will be 1,020 places for persons with disabilities, so we know clearly that there will be a group of clearly defined people. Second, people are often under guardianship, and they may fear reprisals in case they, let's say, come out of the woods and stick their name to a case such as this one. And third, we are sometimes talking about persons with mental disabilities who may not have the capacity to grasp the intricacies of human rights and the rights that they have. And so on that basis, we said, you, Court of Justice, as an entity of the European Union, you also have a obligation to enforce the CRPD and the right to access to justice. To which they said, absolutely not. And so, look, did I expect them to change? No. Was I slightly hopeful? Yes. Because especially the argument, if you simply, because of your disability, cannot stand up and defend yourself, what other mechanism can there be than a third party, an entity defending your rights? And then they said, and I'm looking here at language from the judgment that still makes me angry to this day, that they basically said, any difficulties, however serious, faced by persons with disabilities cannot warrant an action being brought against that measure by a third party. So they basically said any difficulties, however serious, cannot warrant an action brought by a third party. So to my mind, that is actually, and this is going to be controversial, that is a violation by the Court of Justice of the provision on access to justice under the CRPD. Can you do anything about it? This is the highest court, so it stops there, unfortunately.
Yeah, we can only try again, I guess.
Well, the door isn't entirely closed, and we have been looking with you for individual applicants who would perhaps not fear reprisals or be in individual circumstances where they can prove standing. So that is something that we're still working on with you. If there are, and this is maybe a call to our listeners, if there are people who feel that they might be in certain circumstances where their personal safety or personal happiness or personal circumstances would not be negatively affected by litigation, happy to have that conversation and explore what we can do.
Yeah, and I think I work a lot on EU funds at ENIL. I think sometimes people feel like this is very distant from their lives because maybe a directive or a regulation feels very distant from people's daily lives. EU funds are very close to everybody's life. You might go to, a cultural center that has been funded by EU funds. Maybe the metro in your city is funded by EU funds. And for many people, the institution in which you live is funded by EU funds. So it's a very direct action that the EU is doing in breach of fundamental rights. So going back to this shared management notion, how was this to challenge the fact that the European Commission keeps saying, oh, this is not me, it's the member states choosing to spend the money. It's not us.
Yeah, and you just mentioned it. The money has a direct effect on people, and we made that argument as well. We said, look, this money goes to those institutions, and they were called group homes. So we call them mini institutions, basically. And we said, well, because you are not blocking or suspending the money, enabling them to be built. To which the argument was then, well, but if we don't give them the EU money, then the country can just decide to put their own national budget in them. And hence we're not responsible. And the court aligned with that. We were like, well, but no. I mean, you're still giving it your money, so you shouldn't just, because somebody else might pay for it as well. That just does not make sense. That's not particularly logical in my view. And the same with, it's very technical, but shared management, there's like multiple phases. There's the initial review phase, and then the actual calls, and then saying, as long as it's compliant during the actual review phase, we don't look at the later stage anymore. You can hide behind procedural processes, and that's what happens often in shared management, I think. I'm not an expert. You probably know this better than I do, but that's what we've experienced in that case.
Something that the European Court of Justice loves to say is, we're not a human rights court.
Mm-hmm.
What is your reaction to this idea that the European Court of Justice is not a human rights court? Therefore, they don't need to look into human rights.
Isn't every court to some degree a human rights court? especially if you look at some of the discourse that comes out of the court and the European Union in general as being, we are a value-based legal order. It just makes me think about the Economist article recently, the Europe as the last land of the free, especially in the current geopolitics. I disagree respectfully.
And on this case, you said there are other things that frustrated you. We were discussing before. Do you want to address any of the frustrations you had with this particular case? What things, when you read it, you went like, this doesn't sound so reasonable?
Yeah, it's in this case, I think I've highlighted the one where basically, well, look, I know that the court very actively manages its case law burden, the cases that they get, and the rules on standing and who can bring litigation against EU acts is one of those, and that's not exceptional. Many Supreme Courts around the world will actively manage the cases that come in or not, and they must have thought of it from a broader perspective. They must have thought, well, if we now allow one NGO for persons with mental disabilities and give them standing, then we're opening the floodgates. Sure, I can understand that, but then one, is there something wrong with that? And then two, I truly believe that persons with mental disabilities are a unique circumstances where they should have made an exception, because there are other cases, few and far between. For instance, there is a case where persons with disabilities, and it's a case already 20 years old, that proved that they were direct recipients of funds, and if they were involved in that procedure, they would have standing. And to my mind, this was another example. They have, I don't think that the big precedent, the floodgates would have been opened by doing the right thing. So that's a deeply frustrating one. Another frustration and that's maybe more broad from an EU litigation perspective. As a lawyer, I've acted for companies, for governments, and for NGOs. I'm the same person, but depending on who stands before the court, the treatment is very different. If you are there for an EU institution or a member state, you just feel that you are taken more seriously than if you are a private actor. Now, NGOs are still taken slightly more seriously than companies. So, at least in my view, from what I've seen. So that's at least something. But that's another frustration of mine.
That is interesting.
I can continue venting if you want.
I'm happy for you to vent. If you want to take another thing of the case that you found.
Maybe not. Another set of cases that we've done for ENIL and Validity is on transparency and access to documents. And so what regularly happens, of course, for you as an organization, you want to understand, especially in this context of shared management, the conversations that the European Commission is having with the member states. So there is something that is called freedom of information requests. So you as an organization, and actually any citizen, can go to the EU institutions and submit, hey, I want to see documents on this topic from that date. Now, as NGOs, you regularly do that. And then there is a set of procedures and time limits within which the EU has to reply. And we have basically seen let's say, a structural failure of replying in time and replying giving complete replies or partial replies. And we've litigated that as well. It was a case relating to documents from Hungary, where initially the European Commission partially refused. We filed a direct action, and the case went on. And informally, we actually had heard also from conversations with public officials that we were likely going to win. And what the Commission then did is they released those documents anyway, right before a judgment. And then we argued, well, this is a part of a pattern. So you, the court, still need to adjudicate and still say that the European Commission acted unlawfully. But they said, no, you now have access to the documents, so we don't have to rule anymore. What we also did is we submitted them a whole raft of document requests that were failed or too late or partial, and they refused to accept it because it didn't demonstrate anything part of that specific case. So procedural arguments to kind of wriggle out of having to give an answer, even though in my mind it was quite obvious what is happening. So a sense of College of Europe graduates protecting each other. I see people eye rolling. I hope I can still act before the court after this podcast.
You will tell me, we keep this in the podcast. You can think about it for a few days.
Maybe I will reflect.
But maybe to give a bit of background to our listeners about why was this important, this request for information. The way EU funds are structured is not a clear-cut process in which the EU gives money to each member state and they can put it in their pockets and see what they do with it. There is a lot of planning that gets involved and a lot of conversations between the Commission and the member states. And this is what at the time was interesting to know, if I understand correctly, what had been going on in the conversations regarding Hungary, because we knew that investments into institutions were planned. So the other problem here is that there is no good moment apparently to challenge these investments, because when before they are allocated, they say there's still no violation. It's just a plan.
Yeah, and the big discussion in that Hungary case was, and this is actually being litigated now between Hungary and the European Commission. The documents that the European Commission refused to provide us were in Hungarian and allegedly from the Hungarian government. And so what we got was the one side, so to speak, the documents from the Commission, but not the replies from Hungary or in Hungarian. So obviously you wanted to see the full dialogue, the full discussion, so that you could understand and then also advocate as appropriate. And so we litigated against not seeing the Hungarian documents. And what then happened, as I mentioned, was the Commission agreed close to the judgment to release the documents that came from Hungary. But then Hungary litigated against the Commission to release those documents against us. Now that case, eventually the Commission actually won. So Hungary was put in the wrong, but January 25 this year, they filed an appeal. And so, maybe going back to what is a win, did we win that case on transparency? Not per se, but did you get to see the documents? Yes, so that's a win. And is there now still a discussion ongoing before the Court of Justice? Yes, about the fact that even in this context of a dialogue, the Commission can release those documents. So for the future, when NGOs like Validity and ENIL request documents, they are more likely to see the full picture. So these are, drops on a hot plate maybe, or small baby steps, but they are steps nevertheless. So that's strategic litigation. It's rare that you'll get the huge big win, although sometimes you also do. But it's still, it makes a difference.
And for us, it is important to hear we can continue asking for these documents, and now we have basis to say you have to give them to us.
Also, they're from Bulgaria or Hungary, etc. Yeah, exactly.
Any of our members in the different member states can also, or even accession countries, can also maybe start requesting. So that may also lead to more publicity and transparency.
Yeah, exactly.
That would be very interesting.
And that's transparency goes both ways, right? I mean, and I mentioned it earlier. There's actually a Covington and Van Vooren versus Commission, and that's also a transparency case. That's where the Commission refused to disclose to us how the member state had voted on a certain implementing act, and we wanted to check whether they had properly counted the vote, because it was close to a blocking minority. And for the listeners, that basically means that if a small number of member states that have sufficient weight, a certain act can be stopped, that it's not adopted. And informally, we had heard that an abstention was probably counted as a yes, so we wanted to check. And the Commission refused to disclose how individual member states had voted. And it so happened that I had filed that request in my personal name, and so I thought transparency goes both ways. In a democratic society, I want to know who voted how and how you counted it. So that's now still pending on appeal.
That's so we can maybe update in not too long.
Indeed.
And I guess that's also always a difficult question regarding human rights. How do we go from theory to practice? Of course, I'm a state party to a convention. Should be enforcing the convention. How do we get that in practice, as you were saying before? If an individual cannot invoke the convention in court, if in places where it needs to be transposed, it hasn't. I believe the UK still has not transposed the UK is not it's not a EU member state.
Yeah.
But how do we make human rights a reality?
Yeah, you need to have a willingness from the legislature to provide these mechanisms. And if you look at the global level, it's not looking good right now. So in a way, you'd hope that if the EU is the value-based actor that it purports to be, that even in the most difficult of times, we stand behind their principles. We'll see.
And I will ask you a bit about the field. I'm working in this field for maybe any listeners that are feeling inspired. Maybe if anybody's studying law and thinking, I actually want to work in human rights. I like the topic. I want to be a lawyer and work on this. How do you go about it? How do you work in places like Covington, maybe, that do pro bono, or also as a human rights independent lawyer? Is it something that can pay your bills, which is obviously the first concern?
That's when you start your career, how do you... I listened to an interesting podcast recently, and something that stuck with me was find your front line. And what is your front line? I think that's where you need to start. And I was exploring my front line. I was a stagiaire in the Belgian embassy to the United Nations after I graduated in international law from NYU. That was 2006, actually. Funnily enough, as a trainee, I worked on the negotiations of the CRPD that were going on at that time. But that was very fun. There were EU coordination meetings in New York and these kind of things. And I thought that's what I wanted to do, but I saw that international diplomacy was not my thing. Especially maybe for a small country. I felt like I was writing reports and sending them to the headquarters to Brussels, and what happened? Nothing. Plus, that was also when the Israel had just invaded Lebanon, and it was a difficult period. And I thought, I won't be a good diplomat. Back then, I thought, okay, I'll do it through publications and teaching and writing. That's another path that I explored. I did publish a couple of books, but maybe it's the ADHD talking. After a couple of years, I was like, okay, what's next? What else can I do? So then I went into private practice. That was honestly more indeed because also I had a family to take care of, and like you say, you need to pay the bills. I don't think that going into private practice, the big corporate law firm, should be your first choice if you want to be a human rights lawyer. I think you can probably talk more about going into NGO. But when you do and you are in private practice, then it's also still about choosing your area of law and also choosing your firm. Look, if you look at what's going on in the world, you can see that there are firms taking a stance and that there aren't. So you should also find an employer that fits your own wishes, your own priorities, I think. Another area where you can go that I wanted to do, but it was too slow, the hiring process was the Commission Legal Service. So after all these years, I did the concours and I'm still on the list. Think you can probably make a difference there. Yeah, lots of avenues for graduates out there.
And maybe a question I should have probably asked before there was one, but well, now it's done. So we know that in this particular case, the Bulgarian case, we said talking about winning is difficult. We said it, but we could say we didn't win. We could maybe say at least in Bulgaria there was no win. How does that go also as a lawyer? How is the frustration of maybe putting effort in a case that you feel a lot of value to and then not seeing the results?
Well, you get used to it. I regularly joke that I have more inadmissible cases than I have admissible cases, and then amongst them, like I mentioned earlier, if I want to win more, I should represent a government rather than individual companies or persons. But yeah, like I said, you look at the judgment, you get frustrated with parts of it. You see a silver lining, and you need to move on. Can't win them all.
And why do you keep going?
Because it's also fun.
Okay.
Litigation before the EU court is fun, especially if you're a bit of a EU law nerd. It's an interesting court and an interesting place to be in. Yeah, I find it still has more impact than writing lots of articles about it. So, especially also when you are in EU litigation or in litigation in general, there are the cases that you actually see into judgment, but there's a whole lot of cases that never made it to court, or that you settle, or all the processes beforehand or around it. So you get to see a lot of the action. So that's interesting. Yeah, and like I said, sometimes you do win. For instance, for the ILGA, the International Lesbian and Gay Association, we did this case in basically for persons who are not employees but who are self-employed, who were discriminated, and we essentially got confirmation that EU law that protects employees also protects self-employed people against non-discrimination. So sometimes you do win. Yeah. And in Dutch we have this saying, the bumps against the dents, and they make a still an equal.
Thank you so much, Bart.
Thank you.
I think this has been a very interesting conversation, and I hope our listeners enjoy it.
Hope so too.
We've learned that winning or losing a case is a difficult question when we're talking about strategic litigation. In this case that we are discussing today, the case of Bulgaria, yes, we did not win in court, but what can happen now? What can we do with this case? What steps should we take afterwards? To discuss this question, we interviewed also Stephen Allen, Executive Director of the Validity Foundation. We have here with us today Stephen Allen, who is an Executive Director at the Validity Foundation. Hi, Stephen. Could you tell us a few words about the Validity Foundation?
Hey, Rita. It's good to be with you. And thank you for the invitation today to have a chat. I'm Stephen, and yes, I work for the Validity Foundation. Calling in from Budapest today, which is where we're based in Hungary. Validity is a legal advocacy organization that works to promote the rights of people with intellectual disabilities and people with psychosocial disabilities, primarily in Europe and in Africa. And one of the main things we do is try to take strategic litigation, take cases essentially, to enforce the rights of people with disabilities under the CRPD.
Thank you. So in the case we are discussing today, ENIL and Validity took this case in front of the European Court of Justice, and at the core of this legal case is the fact that EU funds were used to build institutions, despite the fact that the Convention on the Rights of Persons with Disabilities does not allow for such investments. How is this possible? How are EU funds regulated to make sure that these investments do not happen? And how is it happening?
I think those are really good questions, Rita. And I suppose without being too much of a lawyer, I want to take a step back and explain, like, why is this even a problem in the first place? How did this happen? Because The European Union, of course, is made up of 27 countries, right? And one of the fantastic things is that the EU, all of those 27 members, plus the EU itself, ratified or signed up to the CRPD. And the CRPD does say, as we know very clearly, that all people with disabilities have the right to live independently and be included in our communities. Now, the CRPD doesn't say specifically in words in the text, stop putting money in institutions. However, that obligation flows from the objective. And the objective here, of course, is so that everyone can live in their homes, in the community with the support they need. So the legal argument under the CRPD is that if you keep putting money into institutions, you're actually preventing people from living in the community and having their own independence. So this is why government should stop it. And this is why the EU should also stop it, because they've agreed to do so under international law. They've voluntarily agreed to ensure that people with disabilities, all the citizens of Europe, can have good lives in the community with the support they require. Now, in the EU, the other part of it is that there's differences across the 27 countries, which means that the EU wants to try and promote greater equality between countries that are historically richer and poorer, with different kind of populations. And so one of the ways they do that is with this funding that comes from the European Union to various countries. And one of the things that should happen with that funding is to invest in projects and programs that can help people live in the community, that can help them, for example, access support they might need, like personal assistance programs or accessible housing, which are the things that essentially allow you to live in the community with dignity. The problem is with this money is that there's relatively weak oversight after the money leaves Brussels or Belgium, and when it lands in somewhere like Sofia in Bulgaria. Because at that point, although there are agreements in place about how the country will use the money, the country itself chooses a lot of the time what projects are going to get investment. And sadly, many countries, Bulgaria included, continue to use a lot of this money for institutions. So to fund big old institutions or even small institutions that they are building with this money. Now, in EU law, really what should happen is that in Brussels, the EU representatives should say to Bulgaria, stop doing that, because it's against the right to independent living. Unfortunately, the European Commission, which is responsible for this, doesn't do this very well. They don't monitor very well. And even when they hear of problems, they very rarely take strong action, like when governments such as Bulgaria in this case decide to use the money for the wrong things. And I think that's the big problem that we all face in the disability rights community here in Europe.
Thank you. I would even say regarding Bulgaria that Bulgaria has been put as exemplary regarding the institutionalization. How come? How do you feel about this?
I think validity, and we wouldn't agree with that, but it's true that a lot of people think that Bulgaria has made some good progress. One of the reasons for that is because during the 2010s, so 2010 to 2015, there was a big plan in Bulgaria to end the institutionalization of children. That was the first step. And one of the ways they wanted to achieve this was by getting children out of those old, big orphanages. And they thought that the right way to go was to create what we now call small group homes. So smaller institutions that would help children eventually progressively move on to life in the community. That was the big idea at the time. Except now we're like 10, 15 years later, we know that many of those children never left those smaller institutions. And actually, a lot of those children, of course, became adults in the same institutions, and they didn't actually change. So whilst at the time, the idea of these small group homes was a positive one, moving people progressively so that they can get back into the community. The truth is that very few people have ever actually left and gone back to the community. And so we argue that was a failed strategy. And because it was a failed strategy, we say that it's important to stop putting money in these places because they haven't worked. They then used that same model of small group homes for adults with disabilities. So they used exactly the same approach. And so it became quite a famous approach. And, some big children's organizations were involved with this. And certainly at Validity, I know maybe for you guys, and we don't necessarily agree that was the right thing to do. And so now we need to see some change.
And how did EU funds play a role in this process? Did they support the small group homes? Did they invest also in larger institutions for adults? Or did they fund any community-based services, personal assistance, services that could have impacted positively regarding independent living?
Yeah, so I think EU funds were used for all of those things that you've mentioned in different ways. The problem is that a lot of the funds were still going and are still going, unfortunately, to segregated settings. So a big chunk of the money that could be used to get people into their homes is actually going to the wrong place. So it's taking away the chances of many people. But some governments, including Bulgaria, have used some of the money to start good projects. And some of these good projects include things like personal assistance schemes, and it will include in-home support for people that they might need to live in their own home. So some of these things have happened, but unfortunately, a lot of EU money has been used actually not just for the small group homes to build them, for example, but we also know now that the governments have even been using it in the bigger old institutions, which is very clear that it can't be defended anymore under the CRPD. And that's because of the way EU funds work. EU funds often are about financing infrastructure. And infrastructure, when you talk to a lot of governments, the first thing they think of is institutions and hospitals, right? This is the things they think about. And unfortunately, we still have a long way to go to get decision makers to understand that social infrastructure is more important for persons with disabilities. That means, people in the community who can support you if you need support. That means ensuring you've got information to access public services. So quite simple things, but it's not always in the mind of the decision makers as the priority.
Yeah, I guess you would say two wrongs don't make a right, and that's also true for human rights. Supporting things that are positive does not erase human rights violation, and investing in institution is a human rights violation. And we need to still learn that lesson, it seems. And when you decided that you wanted to then take legal action regarding Bulgaria, why did you make this choice or trying strategic litigation? Did you try other avenues before you went into strategic litigation?
Yeah, so we did try some other avenues before taking a case, basically. And what happened was in Bulgaria, and with our partners and your members, we were looking carefully at what projects were being planned for financing with EU funds. And we found that one of these projects was clearly going to be investing in segregated settings, right? In residential care, and I think even sheltered workshops for people with disabilities. And the first thing we did is we actually told the government, this is the wrong thing to do under the CRPD, and this is the wrong thing to do under EU law, and you really shouldn't be using EU money for this. We actually did tell them, we complained about it. And so in Sofia, the capital in Bulgaria, the replies we got were simply dismissive. They just disagreed with us. They were happy that the project they wanted to fund was, in their view, acceptable and agreeable. And they really ignored our concerns that building these places is going to create new human rights violations. So that was where it started, and we didn't get very far at the national level. After that, because we knew that this was a wider problem, we also told some people in the European Parliament, okay, about this issue. And we says, in the European Parliament, have you looked at this? Because, you know, EU money is being used clearly in a way that is going to prevent people actually from having their freedom, when it could be used for much better goals. And so the European Parliament did look a bit at this, but we didn't get very strong action. So the final thing then that we decided was that we had to go to the decision makers who are providing the money in Brussels, and this is the European Commission. And we told them about the situation. We explained our concerns that the money was going to create segregation, and we asked them to prevent this. And actually, the European Union can prevent these projects if they have good evidence, and they can say to Bulgaria or to any country in Europe, they can say, please don't do this, stop it. It's going to violate EU law, it's going to violate international law. But I have to say that when we complained to the European Commission, they refused to stop the money being used in this way. They simply refused. They also kind of disagreed with the arguments we were making. At the beginning, I mentioned that the CRPD text doesn't say stop putting money in institutions. It doesn't say those words. And often at the European Commission, they have made arguments saying we still have to put some money to make the places livable so that people are not in a terrible condition. So this is kind of what they did. And essentially, they refused to take action in this case. That was the final thing, really, that meant we had nowhere else we could possibly go. And we decided it was time to take a case. And this case actually was against the European Commission for refusing to take action in this situation. And that was at the Court of Justice of the European Union.
And we know that at the end, the European Court said that there was no admissibility regarding the legal standing, as Validity and ENIL could not represent the people directly affected. Could you explain a little bit about this? Why was this decision? And do you think in the future things could change and there could be a decision in favor of Validity or of ENIL?
Yeah. This is a really excellent set of questions, Rita, because it was very frustrating that at the court, the European court, we also couldn't get a positive judgment. And you mentioned why, and that's because of this kind of legal concept called admissibility and standing. These words mean essentially who has the right to take a case under EU law. And in this case, and in this area, EU law has very restrictive criteria for people who can go to that court. To break it down, that court you can only really go to if you yourself are regarded as a direct victim of something that has happened because of the EU, right? So you have to be able to prove that you are directly or very closely affected by that. Now, the problem in Bulgaria was that the people under this project who were going to be affected by this project from the EU, a large number of those people are under guardianship in that country. What that means is when you're under guardianship, you don't exist for the law. You don't have the right even to go to the courts on your own name. Someone else has to do that for you. This is also a human rights violation. And we explained this to the Court of Justice. We explained that the people affected cannot directly access justice. And ENIL and Validity, we are organizations who are dedicated to fighting for the rights of people with disabilities. It is even in our organizational charters and mandates that this is our reason for existing. And although the court did look carefully at what we said, and they did hear arguments about why we should be allowed to represent the people in these cases, they still rejected our right to represent this group. And what that meant in reality was that the court closed its eyes to a serious set of human rights issues in Bulgaria, in this case, where there was no other mechanism possible for those people to go to have their rights protected. And in my opinion, it shows a serious problem when the European Court is refusing to look at the rights of people with disabilities, especially those who are kept in institutions and under guardianship. Perhaps one of the most profoundly segregated communities in Europe today. And it is shocking to me, really, that the court didn't want to hear this case in full. But I am hopeful, Rita, that eventually we will get through those doors and we will enhance accountability. Thanks.
Thank you, Stephen. I think if I start writing down all of the articles of the conventions that were breached here, I may be reaching 5 or 6 if we're looking at the right to legal capacity, the right to access to justice, the right to independent living. We're at a long list of human rights that have been breached, really. So what is needed to continue strategic litigation regarding EU funds? Do we need to modify the laws that permit access? Do we need to take other legal avenues? Do we need to instead maybe focus on advocacy? What is your view on this?
I think that we're going to need to do all of those things, Rita, and others probably as well, to improve the situation. Just kind of last week, you might remember that the UN looked at the European Union, so the United Nations looked at this problem in Europe and how Europe is doing on implementing the rights of people with disabilities. And they said, yes, you need to improve access to justice. And I think to do that in Europe is going to require some big changes, for example, about how the European Court operates. So we need to think about how we would change the rules about the court so that it will listen to cases, as you say, that are coming from people who may not have legal capacity or have their legal capacity removed from them by guardianship. So yes. We also have other strategic litigation going at Validity, which is about fighting against guardianship laws in the countries. And so I think that's another important part of the picture, is that we're taking other cases, including in Bulgaria, which is highlighting the problems of guardianship to try and get rid of that. But the advocacy, I think, is crucial as well. And one of my favorite events, I always say it, every couple of years, is coming to your freedom drive at ENIL, because you are making the topic of independent living visible to the public. It's not just about something that is happening in a faraway place, that people are less familiar with. This is showing really in the European Parliament to the European Commission that citizens with disabilities are demanding something changes. And I think that we have to keep that pressure up. I think that's really, really important. We also have to do a better job, honestly, at listening to people who have to live in these institutions, because often it's me talking about them or no one talking about them or ENIL. But actually, I think what can really make a change is understanding from the experience of people who have lived in these institutions what it's really like, and what it's really like to have your freedom restricted and to be separated from your families and from your community and from your friends. I think that's powerful, and we should do as much as we can to get those people's voices out there. And I hope you're going to get to talk to some of the people we worked with, Rita, and these are the people who are the real experts who can get us on the right track, and they should be respected for that.
Yeah, you're absolutely right, and I'm really looking forward to having them on our podcast. I also just want to maybe raise one last question that came to mind while you were speaking. It is something that the European Court of Justice often says: they are not a human rights court. That is something that they have said in multiple occasions. This case was about EU funds. It is about human rights for us, but it's not only about human rights. But how do you perceive this idea that the European Court of Justice is not a human rights court?
I find it a strange argument. I know that they say this. I find it strange because the one thing I think we all have to understand about human rights is that they're universal. Universal means they apply everywhere all the time. And you can't just say, we don't do human rights in this court, because if you are dealing with cases that involve people, you are definitely dealing with issues related to their human rights. It's undeniable. And independent living is a perfect example of this. It's about the right to just live in the community, which is a human right. It's a human right that the European Union has agreed to. It's also a human right that is being violated with EU money. So we cannot separate the issues, and nor can we accept, I think, this quite circuitous argument almost from the European Court of Justice that we don't do human rights, we do other law, but we're going to not listen to persons with disabilities as if they're not full citizens of the European Union. To me, it's a mistake for the court to take that approach, because it means that people start to lose trust in the EU as being beneficial in their lives. And it means that people start, I think, to lose trust that they have real access to justice. So I don't think we should accept that from the Court of Justice, and we should be having a discussion with them about how they need to do a better job in defending the rights of people with disabilities, but also defending EU law. Because what they must do, and the court is the place to do this, is step in when EU money is being used in a way that is damaging people's lives, violating EU law, and violating the EU's obligations under international human rights law. Courts shouldn't be trying to close their eyes to those topics. They should be opening the door to justice.
I think that's a very good quote to end, because we know ourselves and we know we could speak on this topic for a few hours if we could. So thank you so much, Stephen. Thank you for your remarks and your explanations. And have a good day.
Thank you, you too. It's been a great chat.
Opening the doors to justice. That is why we do strategic litigation. To make sure that those that cannot be represented, that cannot act for themselves because of the laws in their countries, can access the justice they need, can get reparations and remedies for the injustices they experience. This is how we will keep working, and we will also be reflecting about how do the next regulations for the EU budget can make sure that people can access the justice they need, but that there would also be no more investments into institutions and any other form of segregation. It is important that we work together, pro bono lawyers, disability organizations, and the victims, to make sure that justice is accessible and that we together achieve our goals to implement the UN CRPD and that the institutionalization can become a reality.
Thank you for tuning in. We hope you'll join us again next time as we continue to advocate, collaborate, and innovate for disability rights. We also would like to thank all our speakers for sharing their experiences with us and for allowing us to learn from and build on them. This podcast was brought to you by the Litigate project.